Welcome everyone to a special episode of the Federal Bar Association Ketam Sections, The Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, Programming Committee Chair of the Ketam Section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello! You have your celebratory jacket on, and we all know why, because today we are focusing on Wisconsin Bell versus U.S. ex-rel Heath, specifically a 9-0 decision handed down by the U.S. Supreme Court on February 21st. You argued the case at the Supreme Court, Tejinder. Congratulations to you and your client.
Thank you. Thank you. We had a great teamwork on this case and had the great fortune to be completely right about everything. So,
well, let's also acknowledge that this is not your first time at the Supreme Court. In fact, you are now 4 for 4, 3 for 3 on FCA cases. You've never lost a single justice's vote. Wow, that is an amazing record. Congratulations.
We will try to keep that streak going.
Okay, so let's focus on oral argument first. It was fairly clear in oral argument kind of the way this was going. You weren't really sure how broad the decision would be. Tell us what the issue was, Tejinder, and how Justice Kagan handled it in her opinion.
Sure. This case arises out of false claims presented to the E-rate program, which is a telecom subsidies program for schools and libraries. The way the program generally works is that telecom carriers give discounted services to schools and libraries, and then they get money, the carriers get money from the government to make them whole for the discounts that they offered. And the discounts can be substantial, up to 90% off, depending on how poor the school or library is. The program rule that was violated here is that there's a rule called the lowest corresponding price rule. And basically what it says is that the carriers cannot charge more than they would charge similarly situated commercial customers when they build the schools and libraries. And the idea there is, you can imagine that if the carriers just inflated the bills ex ante, then give a big discount to the schools and libraries would pay more than they should be, and the government would pay a ton more in subsidies. And so they have to limit their pricing. Wisconsin Bell, which is an AT&T subsidiary, didn't do that for a large period of time, and so an FCA case was brought against it. The reason this case got to the Supreme Court is there is a little bit of a quirk in how this program is funded. The way it is funded is that telecom carriers contribute money to the Universal Service Fund, and they frequently pass that obligation on to their customers. If you look at your cell phone bill at the bottom, you'll see a USF surcharge. That's this money. So this money goes in through the telecom carriers to the fund. Until 2018, they were contributing it to a bank account that was administered by the Universal Service Administrative Company. We'll just call it the company. The company is a private not-for-profit. It was created at the direction of the FCC to administer the universal service programs, including the E-rate program, in much the way that administrative contractors administer, for example, the Medicare program. They just make sure that the invoices come in and the checks go out as they are supposed to for valid claims. But they do it all under the supervision of the FCC. The FCC sets the program rules that decide how much money has to come in and how much money goes out and to whom. And so what Wisconsin Bell said is they said, look, the False Claims Act only applies if the government provides at least a portion of the money. Here, the money is coming from private telecom carriers to the account run by the private company and then going out to the private other telecom carriers that provided the services. And so it never actually touches the government treasury. It never goes through government hands. The relator and the government's answers were essentially twofold. Number one, that doesn't matter. The government is the one making the money move. It sets all the program rules. Without the government's action, this money would never have been paid in or paid out. And so the government is providing the money, even if the government doesn't touch the money itself. Number two, Wisconsin Bell was actually wrong about the facts. During the relevant time period, approximately $100 million was put in this bank account by federal agencies themselves. About 50 million of this came from the FCC, because when telecom carriers don't pay into the fund as they're required to do, the FCC goes after them and collects the money through administrative enforcement actions or debt collection actions, takes that money into treasury accounts, and then moves it into the company account. Second, the Department of Justice sometimes goes after people who commit crimes in connection with the program or False Claims Act violations. It puts that money in treasury accounts and then puts it in this account. And so that narrower theory that the 100 million gets us home because the government provides at least a portion of the money is what the Supreme Court rules on in our favor. It says, look, it does not really matter whether the government provides all of the money because it provides at least this portion. And the statute says that if the government provides any portion of the money requested or demanded, that is sufficient. And so that is the scope of the majority opinion. The most interesting part of the majority opinion is that Wisconsin Bell's answer to this was, well, it doesn't matter that the government actually physically takes it from us, puts it in treasury accounts, and then moves it, because really it's just moving it on our behalf. It's just making the movements that the carriers ought to have made on their own. And so you should treat it as if the carriers were still doing it, even though they were coerced into doing it, and even though the government took the money. And the court says, no, that's obviously wrong. And even if we're right that the carriers are also providing the money, it would be wrong to say that the government is not providing the money. And so the court makes it really clear that whether the government is acting as the source of the funds or a conduit for the funds, it doesn't really matter. If the government touches the money, that's going to be enough.
So where does it leave the broader theory, though, Tejinder, where the government doesn't touch the money? What's the status of that theory as you see it?
The court does not reach it. And so for purposes of this case, the Seventh Circuit issued a precedential opinion saying that the broader theory is also correct. That is, that the government can provide funds by setting up a government program, setting all of the rules, and making money flow through it, even if the government doesn't touch it. I don't read that holding to have been vacated. And so I think that in the Seventh Circuit, at least, the law is that that's right. Now, in the Fifth Circuit, there was a previous decision about this program, which gave rise to the circuit split that led to the Supreme Court case. And there they said the money has to come from the Treasury. And so in the Fifth Circuit, the rule might be different. But in the Seventh Circuit, at least, it seems pretty clear. And I think most courts would probably be inclined to follow the Seventh Circuit view, although not necessarily.
So let's talk about who this benefits. Who in the FCA world does this clarity benefit prospectively?
Obviously, cases involving the Universal Service Fund have received a boost in addition to the Wisconsin Bell case. There are other cases under the USF. You'll see periodic notices of these cases settling. And so this takes an argument off the table in all of those cases. There may be a handful of other government programs that have a similar structure. That is, where private parties are sending money to the program, but it's moving briefly through government hands. All of those programs are similarly now clearly covered, even if the government is merely acting as a conduit for the money. So too, cases in which private parties act as conduits for government money. There is a bunch of cases about municipal bonds where the defendants have said such claims are not covered because really the money comes directly from a private source, even if it originated with the government. I think the opinion here makes clear that those cases are going to be covered as well. But I actually expect the practical impact of this to be relatively narrow, because in most cases, the funds are going to come from the Treasury, or they're going to be, the person dispersing the funds is going to be at least an agent of the government, which is an alternative path to the statute applying.
So let's move to the two concurrences. The first by Justice Thomas. Tell us about that.
Justice Thomas's concurrence says, yeah, I agree that because of the $100 million, the court resolves this question correctly. But he is skeptical about the broader theory. So in Justice Thomas's view, the False Claims Act should not necessarily reach cases where private funds are moving through a sort of private ecosystem. And he raises concerns that the defendants raised as well, including like, well, there are lots of situations where the government causes somebody to pay money. One example is the court system may order a judgment to be paid. Or what if the government mandates a minimum wage? Would that mean that every recipient of the minimum wage, if they are subsequently defrauded, the False Claims Act might apply? And the answer to that, I think, is quite clearly no. I think for two reasons. First, in order for the provided part of the definition to apply, the money has to be moving in connection with a government program or interest. And I think in those purely private cases, it's not. But separate from that, I think you wouldn't say that the government is necessarily providing the money either in those situations. Even if it provided it in the sense of causing it to move, it doesn't then control its distribution as directly as it does in connection with government programs. But Justice Thomas raises the concern, and the defendants raise it too. So he floats it out there for consideration, and he got Justices Kavanaugh and Alito to agree that that is a consideration.
And then we had a separate concurrence. Justice Kavanaugh, he writes a brief concurrence, again, hearkening back to whether the qui tam provisions of the Federal False Claims Act themselves are constitutional. Zafirov is currently pending in the 11th Circuit and shortly will be fully briefed there. In Justice Kavanaugh's concurrence, Justice Thomas signs, but one justice is notably absent from the concurrence. What do we make of that, Tejinder?
So yeah, you can say notable. So the backstory here is that in the Polanski decision, there was a similar opinion. This was by Justice Thomas, a dissent then. And then there was a concurrence by Justices Kavanaugh and Barrett saying, oh, we should look at these constitutional questions Justice Thomas raises in an appropriate case. Justice Kavanaugh's concurrence here basically says the same thing. In an appropriate case, let's look at the constitutional questions. He's joined by Justice Thomas, but not by Justice Barrett. And some people are reading into this, like, oh, what does it mean that Justice Barrett didn't sign on this time? I think it would be a mistake to read too much into this. Look, I'm an optimist, and so I'll read into it that Justice Barrett has changed her mind and decided the False Claims Act is clearly constitutional. But I think, honestly, that's probably reading too much into it. She may have not signed on because she changed her view. She may not have signed on because she just doesn't feel the need to repeat herself, having already, put up the flag in Polanski, or it could be any number of other reasons. This is a situation where, in general, I am not the kind of person who says you need an insider whistleblower to know what's going on, but this is a situation where you actually might need one. And so I think there could be a lot of speculation, but there's not a clear signal that I would take from this.
Tejinder, congratulations again. Thanks to each of you for joining us for this special edition of the Federal Bar Association qui tam sections, the Rounds FCA News with Tejinder Singh. We'll see you next time.